Hello and welcome everyone to Do the Rights Thing, a workshop about disability rights in employment. My name is Jessica DeMarinis and I am a staff lawyer at Arch Disability Law Center. I am here with my co-facilitators, Melanie Marsden Myers and Diane Wintermute, to deliver the workshop today. I want to start off this afternoon by giving the floor to Melanie for a land acknowledgement. But before I do that, I will just pause very briefly to make sure that everyone who is needing accommodations for this session is able to access those accommodations. You should have received an email earlier this week about those details. And if there is any problems with the accommodations, I would encourage you to use the chat function, which will connect directly with our people behind the scenes to get you connected. And with that, I will turn it over to Melanie. Thanks, Melanie.
Thank you, Jess. So as customary, as an Indigenous person, I'm going to introduce myself and then go into the land acknowledgement. My name is Melanie Marsden Myers. My Indigenous name is She Carries the Light Woman. I am registered with Alderville First Nations Reserve. I am Ojibwe and Mohawk, and I am Bear Clan. I am also blind or visually impaired. We acknowledge that participants attending this workshop are situated in various communities across Ontario and in other provinces. As we watch trees change for fall and animals ready for colder weather, we are aware of nature and the importance of caring for it. We further acknowledge that the first peoples of Canada have been the stewards of this land for at least 12,000 years. And we honor the contributions that Métis, Inuit, and other Indigenous peoples have made, both in shaping and strengthening this province and the country as a whole. We who sit at this table are aware of our role to peaceably share and care for the resources around Ontario, Great Lakes, as set out in the Dish with One Spoon Wampum Belt Covenant and Agreement, the Iroquois Confederacy, the Ojibwe, and allied nations. For those who are settlers, they are grateful for the opportunity to live, play, and work here. We thank all the generations of peoples who have taken care of this land upon which we meet. This recognition of the contributions and historical importance of Indigenous peoples must also be clearly and overtly connected to our collective commitment to make the promise, and the challenge of truth and reconciliation real in our communities. In particular, we commit to bringing justice for murdered and missing Indigenous women, girls, transgender, trans-identifying, and two-spirited peoples. Today, on behalf of Arch, it has been an honor to offer the land acknowledgement as an Indigenous disabled woman in the spirit of creating an inclusive, safe space where people can be part of an honoring the presentations, engaging in conversations, and moving the employment conversation forward in respectful, safe, caring ways, in which we know that we are all doing our part in the best way we can. I thank other Indigenous peoples who have expressed this land acknowledgement and given me permission to build on it, make it my own, and share it with everyone this afternoon.
Thank you, Melanie. Melanie, if you could also take us through our agenda.
Absolutely. So the overall, so we begin this workshop this afternoon, first with housekeeping details. Then we'll have a background about Do the Right Thing project. Then we'll have some legal information about disability and in employment. Then there'll be a break. Then we'll open the floor or open the Zoom room for conversation for practice and questions. And that's, I'll turn it back to Jess.
Thanks, Melanie. So as Melanie said, the first thing we do want to take care of are just a few housekeeping items. So first of all, the format of the workshop today, we will be taking you through, we'll keep it as short as possible. Want to be very high level with our basic legal information about the rights of persons with disabilities in the workplace. Because then what we want to do is for the second half or the second part of the workshop, we really want to turn it over to all of you and consider some scenarios and really just have a more in-depth discussion about how these high-level principles apply. So we'll really get into the principles and kind of how they work in practice in the second part of the workshop. We will ask everyone, all participants, to have your audio off or muted and your video off for the first part where we're giving the general explanation. And we'll ask everyone to hold their questions for the second part. This session has ASL interpretation and captioning. An ASL interpreter will be available in a video window throughout today's participation and in the discussion. You can keep this video in view by pinning the video at the top of your screen. If you just hover over that particular video, for example, you'll click pin video. At about every 15 minutes, what we will do is just have a pause in our discussion to allow for the ASL interpreters to switch and for that video to be pinned. Captioning is also available using the stream text link that was sent to you by email. If you are having difficulties accessing this, as I said, you can use the chat function and connect directly to the people behind the scenes who can assist you. The first part of this workshop, where we're discussing the high-level concepts and the general legal principles, will be recorded. The recording will be stopped once we transition into the participation period. The recording eventually will be available on ARCH's website. We do have to tell everyone today that the information we talk about is that legal information, not legal advice. The reason why we can't give legal advice via a workshop is because there is an important relationship between a lawyer and a client that involves confidentiality, which we obviously don't have here today. So the information we provide is information, and if you are needing to speak with someone about legal advice, we would encourage you to connect with a lawyer, just yourself. There is a survey that we will ask everyone to fill out after the workshop that will be circulated tomorrow. And it just lets us know what you found useful and how we can do these workshops better in the future. Oops. There we go. Okay, so quickly before we get into the legal information, we did want to share with you a little bit more about this project. So this slide has a graphic along the bottom that has a number of hands being raised. There are a number of different colors, and you can see their sleeves. So they're sort of have their hands raised and they're engaged in whatever they're doing. the Do the Right Thing project is a partnership between Dawn Canada and Arch Disability Law Center. Dawn is an organization that works to advance the inclusion of deaf women and women and girls with disabilities in Canada. Arch, where I work and where Diane works, is a specialty legal clinic that practices exclusively in disability rights law. We offer public legal education, summary advice and referrals, and law reform and test case litigation, and continuing legal education for lawyers and paralegals. Our client group is persons with disabilities across the province. Together, Dawn and Arch strive to better understand how women access employment through this project. We have been working over the phases of this project. We've been working with employers and human rights organizations, women with disabilities and deaf women and other stakeholders. And the goal is it's addressing the sort of systemic barriers that this group is facing. And our goal is to develop practical tools, education materials, and public awareness campaigns on the human rights obligations of employers and service providers. The first phase of, and I will just pause there just to allow our ASL interpreters to switch. So the first phase of this project happened last year, where we held a number of focus groups and key informant interviews and distributed questionnaires, where we connected with deaf women and women with disabilities to hear about their experiences in the workplace or trying to get into the workforce. Based on the findings from that first phase, we are now in phase 2, where we use that information to inform these legal education workshops on disability law in the workplace. And so there was originally a first, not originally, but last week we had a session for women with disabilities and deaf women, and today is the session for employers and service providers. So what we learned in phase 1 is that many participants, so many women with disabilities and deaf women, experience violations of their rights in seeking employment and maintaining employment. We heard that many didn't know how or when to disclose disability. Disclosure in particular was a particularly problematic topic in terms of knowing how to navigate that relationship. We learned that there needs to be more education for both employees or prospective employees and for service providers and employers. So that takes us to our goals of today. And Melanie, do you want to talk a little bit about what we're hoping to do today?
Sure. So the goals for today is to promote a solid understanding on disability rights in employment, to understand the roles and responsibilities of employers and employees, and to apply legal principles to scenarios involving disability in employment. Arch, as Jess just mentioned, hosted a workshop last week, and then we're doing the one today as well for service providers and employers. Arch extensively outreached. So in order to get the word out there, we developed promotional materials in blogs. We had save the date flyers, and we had the invitation. And so that extensive outreach went to many disability communities and deaf communities in Ontario, including but not limited to listservs, Twitter, newsletters, Facebook, network, various coalitions, colleges and universities and banks, employment agencies, and the like. So we wanted to ensure that this workshop was, in terms of the promotion, was promoted far and wide. So that's what the outreach looked like for phase 2.
Thanks, Melanie. So there are a number of laws that affect or intersect with disability in the workplace. But for the purposes of this workshop, we're going to consider 2 types of laws. So the first one is human rights laws. And these laws, they give a person, it's what we call rights conferring legislation. So it gives a person the right to be free from discrimination, or the right to be free from harassment in a number of different social areas. And that right exists with the person, that person carries it with them as they interact in these various social areas. And it's elevated to quasi-constitutional status. So it's said to sort of sit above our provincial laws and our federal laws, in the sense that these human rights laws are informing and kind of interpreting the laws that impact us on the ground. The other kind of law is something called accessibility laws, which set minimum accessibility requirements for businesses and organizations. And so what we say that those are sort of the floor of the requirements, while human rights laws tend to be kind of not the ceiling, but they sort of expand the laws from that minimum. I'll take a moment right now to talk about human rights laws and what those mean in the context of employment, and then I will turn it over to Diane to talk about accessibility laws. So in Ontario, human rights law is the Human Rights Code. Federally, for Canada, it's called the Canadian Human Rights Act. In Ontario, this code, the Human Rights Code, gives you the right to be free, a person, the right to be free from discrimination when doing all sorts of provincially regulated things, like looking for a job or working at a provincially regulated organization, going out to eat, shopping, going to the movies, or going to school. So that's when the Human Rights Code would come into play. And if you're doing those things, of course, within the province of Ontario. Federally, the Canadian Human Rights Act is the act that says you have the right to be free from discrimination from businesses and agencies that are federally regulated. So an example of those organizations would be something like banking or Canada Post, anything like air travel, airplanes, and then telephone companies as well. So if you're interacting with those organizations, the Canadian Human Rights Act applies. At its most basic, the Human Rights Code says that persons with disabilities have the right to be free from discrimination and harassment in employment. And so sounds basic, but it's really important we unpack parts of this sentence and what does this actually mean? And how does this interplay with the workplace? So if we think about first the term disability, what does that mean? What does that include? It includes a lot, in short. It's interpreted very broadly. So it means that many things could be a disability beyond sort of what has a diagnosis. There is a number of things that are listed and set out in the Human Rights Code, but we know that it is broader than that. As I said, it can include disabilities that have a diagnosis, but it also, doesn't necessarily have to have a diagnosis in order to fall within these protections. So the Human Rights Code itself does include things like a physical disability, an intellectual disability, mental disabilities, or communication disabilities. But again, as I said, it goes beyond that. It includes things like episodic disabilities, which may only impact a person at certain times. It may be predictable or non-predictable. It also includes non-evident disabilities or disabilities that you may not see from or know that are there from just looking at the person or interacting with them for the first time. And it also includes something called perceived disabilities. So when someone thinks or assumes that a person has a disability, those instances are also protected by the term disability in the Human Rights Code. Melanie, did you have something to add sort of from an intersectionality perspective about this definition?
Yes. So when we talk about disability, it is important to honor a person's whole identity and the many social locations and identities they have. Many of you may have heard of this term intersectionality. It was coined by Kimberly Crenshaw, and it describes the ways we all have multiple identities and social locations. For example, my intersectionality identities are Indigenous, disabled, and woman. All of these social locations must be protected by employers so that an employee's intersecting identities of disability, race, class, gender, ethnicity, and culture are respected in the workplace.
Thanks, Melanie. Yeah, it's so important to think about that, because someone's experience of a barrier in a workplace may be compounded or may just be very different depending on some of those intersecting grounds. And so it's really important to be thinking about how those barriers affect people differently. So exactly. So we think about the next portion of that definition is employment. So what kinds of social areas does the human rights protections come in the workplace? And so like the definition of disability or like what's included in disability, employment is similarly interpreted very broadly. So sort of any expression of workplace or kind of attempting to get into the workplace. So full-time, part-time, short-term work, contract work, short internships, and even volunteer work is all included and protected by our human rights laws in Ontario. And then at the same time as protecting all of those different kinds of work, it also comes into play sort of at every stage of an employment journey. So in the interview process and hiring, in job training, rate of pay, of course, equal access to promotions, equal benefits, and then of course all the way through termination. We have these protections from discrimination. And then the last piece of the protection set out by the code is, of course, discrimination. And so what does that mean? Discrimination is when an employer treats an employee differently because of their disability, or at least in part because of their disability, and that negative treatment, and that different treatment has a negative impact on them. Now, discrimination can take a number of different forms. So there's what we call direct discrimination, when an action itself sort of overtly differentiates on the basis of disability. So for an example, kind of an obvious example is someone's job ad that says we prefer to hire younger people, something like that. I mean, we don't see that kind of thing anymore, but that is an example of direct discrimination. The other kind of discrimination, or another kind of discrimination, is called indirect or constructive discrimination. And this is the one that is trickier because it is carried out through what appears to be, on its face, a neutral rule or practice, but the way it's actually applies in practice is that it has the effect of singling out or having a different impact on a particular group of people. And that results in that unequal treatment, which has the negative impact on the person. So, an example of that is a job ad that has, a requirement of a driver's license. That is seemingly neutral, but the effect of that is that persons with disabilities who maybe can't get a driver's license, are negatively impacted by the rules set out in that job ad. The third kind of discrimination is something called systemic discrimination, which is something sort of more, it's often very hard to prove because it's a sort of patterns of behaviors or attitudes, unspoken things like that, or patterns of policies or practices that create or perpetuate like a relative disadvantage for persons with disabilities. And barriers, so barriers that are discriminatory barriers can be on any number of things in the workplace. So we can have physical barriers, so inaccessible buildings or inaccessible doorways. It can be technologies or even just workspaces. But it also is non-physical things. So things like attitudinal barriers or workplace rules or job requirements. Attitudinal barriers are tricky to prove as well. It's similar to systemic discrimination in the sense that it's these sort of unspoken kind of general feelings or energies in an employment scenario that creates an environment that's perhaps hostile or just not safe for a person with a disability to either make accommodation requests or to voice the fact that they feel like they're being discriminated against. Now we know that to discriminate, it certainly does not need to be intentional. It can be something that the person may have had, or the employer or the service provider may have had the best intentions by putting a rule in place, but the sort of unintended consequences could be discriminatory. Melanie, thinking back to that intersectionality perspective, do you have something to add in kind of when we talk about the definition of discrimination and how it kind of surfaces in the workplace?
Yes, I do. So these experiences affect a person's intersectional identities, as I've mentioned earlier. If there is any kind of discrimination or harassment within the workplace, not only is it emotionally, professionally, and or spiritually harmful it also adds another layer of difficulty in that you have to prove it, right? And so, because of the intersecting nature of not only knowing which part of your identity is being discriminated against, it's also without policies and procedures in place to prevent discrimination, it increases the likelihood of discrimination. And so, I would encourage folks to think about um, how how should employers and or service providers or organize events, or how can employers or service providers improve the workplace regarding office space and or technology? So it's just a comment to think about with the example that I gave.
And that's perfect, Melanie, because the next thing I wanted to talk about was accommodations, which are the changes that are made or the things that are put in place to prevent the negative impacts from discrimination. These accommodations are those things that give persons with disabilities and other intersecting grounds equal opportunity to get a job and to perform their job in a meaningful way. So for an example, if we think back to the driver's license example, it would require an employer to think about whether that job can be done using a bus or a streetcar, or a bicycle or walking or other modes of transportation, to get that job done in the same or equal way. And so in putting these accommodations in place, the employer has what's called the duty to accommodate. And it is what's called sort of there's two obligations happening. So one is on the part of the employer and one is on the part of the employee, or prospective employee. But let's first talk about kind of what are the employer's responsibilities in this relationship. So they have to create a space and a process for making accommodation requests. And this is something that Diane's going to talk a little bit more about when she talks about kind of the accessibility laws and what they require. But it also links back to that idea of sort of systemic discrimination or things that are sort of more attitudinal barriers. So if you create a workplace where persons with disabilities know that they can ask for accommodations and that's a welcome conversation that people want to take part in, that goes a long way in creating a positive workplace. So your, as an employer, responsibilities are to talk to the employee or the prospective employee about what accommodations are needed, so have that conversation, and work with them to find an appropriate solution. It may take some creativity, it may take some different ways of thinking about the task, but it is your responsibility as an employer to have those conversations and to really engage with to figure out what's going to work. If necessary, and only if necessary, it's appropriate to ask for more information about a disability or needs, so including maybe a medical note. But that's really only necessary if the accommodation is, particularly, maybe particularly challenging to put in place, or maybe there's some information that the employer doesn't understand about what the needs are. Because really the starting point is that employers are required to take those requests for accommodation in good faith. They are required also to keep those accommodations request confidential, and any information that kind of comes flowing from that accommodation request also has to be kept confidential, and really only disclosed to kind of the people who need to know to put it in place, so a need to know basis. And the accommodation has to be put in place in a timely manner, so as you actively engage in the conversation and then actively engage in putting the accommodation in place, that would that's what's required by timely. And there's also some narrow requirements, and it's sort of an evolving area of law of the duty to inquire. And that's where there's something that signifies, that the employee, may need some accommodations. And so we'll talk a little bit more about that in our question period, but kind of how to navigate that and what is required of an employer for the duty to inquire. Now, in this relationship, as I said, the employee also has some responsibilities as well. So they have to tell the employer that they need accommodations, equally participate in those discussions. They have to be prepared to try different accommodations as long as those are satisfying and meeting their needs. And then again, only if necessary, comply with those requests for more information. But they are not required to share their diagnosis or the cause of their disability whatsoever. Undue hardship is the principle that says, or is the limit, the only time an employer can actually say no to an accommodation request. So when does an accommodation request reach that point of undue hardship? You'd want to think about three things. So one is if that accommodation is sort of so costly, it becomes kind of impossible to pay for, or which, to the point of almost bankrupting or causing the employer to go bankrupt. You also have to consider outside sources of funding, kind of as a part of considering the costs to help pay for the accommodation. And then health and safety is an important one too. So if the accommodation requested would cause health and safety risks, that may be also a reason that the employer is allowed to say no to that request. So those are the basic laws that flow from our human rights legislation in Ontario. But as I said, there are two kinds of laws. So I want to hand it over to Diane now to talk about accessibility laws and how what's entailed in those and how those maybe are similar or different than our human rights laws.
Thanks, Jess. So not unlike the human rights laws, there are two sources of accessibility laws in Canada. The first is provincial jurisdiction, and that law is the Accessibility for Ontarians with Disabilities Act, or the AODA. There's also the Accessible Canada Act, or the ACA, for organizations or employers who are subject to federal regulations. Today, I'm going to focus on the AODA, although it's worth noting that the ACA is following a comparable process to how the AODA is organized. As a bit of background, the AODA was unanimously passed by all parties in the Ontario legislature in 2005. It promises a fully accessible Ontario for persons with disabilities by 2025. The goal of the AODA is to identify, remove, or prevent barriers by developing standards that set minimum requirements in key areas of daily life. The current standards are the customer service standard, the transportation standard, design of public spaces, information and communications, and employment standard. The government is also developing standards for healthcare and education. And within the education standard, there's one standard for kindergarten to grade 12 and another one that's being developed for post-secondary education. Today's focus is on the employment standard. And I noticed from the list of participants in this workshop that many of you are large organizations who may be very familiar with the requirements under the employment standard. So I'm going to go through them in a fairly high level or quick manner, just to point out the various requirements under the standard that would apply to workplaces. The employment standard requires employers to make their employment practices and workplaces accessible through the job journey of an employee. It starts from advertising and recruiting for the position all the way to return to work policies. It requires that employers provide an inclusive workplace that respects the diversity and skills of its employees with disabilities. The employment standard applies to all paid employees. Unlike the code, the employment standard does not apply to volunteers. Still, an inclusive workplace would also respect the talents of volunteers with disabilities. The disability under the AODA is equally broad as the one under the code. It captures emerging or new disabilities. So disability is not a static concept, but one that continues to evolve. Organizations must make accessibility a normal part of the recruitment and hiring process. So, for example, one of the things that an employer could do is advertise on websites or on disability-specific websites that they encourage applications from equity-seeking groups. Employers must also tell applicants that they can ask for accommodations for the interview. So an advertisement could read, "We welcome or encourage applications from equity-seeking groups, and accommodations will be provided upon request for the interview." If an applicant selected for an interview makes an accommodation request, the employer must consult with the applicant so they can provide the most appropriate accommodations during the interview process. And this consultation is a really great opportunity for employers to get firsthand information about making their workplaces more accessible to persons with disabilities. Candidates with disabilities will often know what accommodations are best for them. When making a job offer, employers must notify the successful candidate of their accommodation policies. They must specify whom the applicant should contact if they want to make an accommodation request. And employees with disabilities should be encouraged to make accommodation requests as soon as possible. If that happens, then suitable accommodations are implemented before the applicant's start date. So there won't be a delay in the employee with a disability becoming a full participant in the job requirements. Applicants who communicate differently will let you know how they do so. Some communication styles and methods could include ASL interpretation, speech reading, using hearing aids or assisted listening devices, understanding straightforward language or communication instead of using idioms or figures of speech, writing or using augmentative or alternative communication devices. Some general tips to keep in mind are, if you're wondering whether a candidate needs any help at any stage of the employment process, ask. An employee may need an accommodation, but be leery of asking for one at the early stages of the employment process because they don't want to be seen as being someone who requires additional supports from the employer. Unless an applicant requests otherwise, you should speak at a normal pace and volume. You speak to the applicant directly and not to a support person. You don't touch a service animal or a mobility device without its owner's permission. And if an applicant doesn't know how much information to offer in response to a question, let the applicant know when you have received enough information, or alternatively, whether you need more. When an employer hires a person with a disability, they should make sure that workplace information is available in accessible formats. And the kind of information that needs to be made available to the employee is how the person with a disability would prefer to receive information and communications, any information that the employee needs to perform their job, like a job description or manuals, and information that is available to all other employees, such as the policies and practices of the employer, health and safety information, personnel policies, company newsletters or bulletins. Generally, it's the information that all other employees receive, and you need to make sure that that information is provided in an accessible manner to employees with disabilities. Large companies need to develop and document individual accommodation plans for employees with disabilities based on a clearly written process. So for example, the process for creating individual accommodation plans should include how an employee can request accommodation or take part in developing an accommodation plan. It should let the employee know that they will be assessed on an individual basis. It will let an employee know that they can request a representative from the workplace or the union to join or take part in developing the accommodation plan. The employer can request an evaluation by an outside medical or other healthcare expert at the employer's expense to assist the employer in determining if or how accommodations can be achieved. Similar to the Human Rights Code, the process for creating accommodation plans should also include steps to protect the confidentiality of the worker's personal information. The accommodation plan should also discuss how and how often the plan will be reviewed and updated, and an explanation of why, if a plan or a particular accommodation was denied, why, and how the plan will be given in a format accessible to the employee. The employment standard also speaks to performance management and career development for persons with disabilities. And so employers are responsible for ensuring that these two aspects of employment are accessible to the employee with a disability. When giving any kind of feedback to a worker, employers must consider the disability, and they can use the individual accommodation plan for reference on how they can do that. Similarly, employers can promote employees with disabilities or transfer them to new positions as they would other employees. There's also a requirement for individualized emergency response plans. So an employer must provide an emergency response plan for persons with disabilities and can share that emergency response plan with an employee or a staff member who is assigned to assist the person with a disability during the emergency process. And finally, there is a return to work process, and large or public sector organizations must have a return to work process in place for workers who have been absent from work due to a disability and require additional disability accommodations in order to return to work. If the return to work provision under any other law covers an employee's injury or illness, the highest possible accessibility for the return to work process is the one that should be adopted. Because we need to remember that the accessibility standards are the minimum standards or the floor of accessibility practices for employers. But there can be higher requirements under other laws like the code or like the Employment Standards Act that need to be taken into account. And if they provide for a higher level of accessibility, then those are the ones that apply. One of the questions that we are often consulted about are service animals. An employee with a disability is entitled to have a service animal with them during their job day with very limited exceptions, and that would be in food-related businesses. With non-evident disabilities, people may not look disabled, but their conditions can affect how or whether they perform certain tasks. And one of the things I would say about non-evident disabilities is that if, for example, you notice that someone who has a stellar employment record is starting to underachieve, instead of assuming that it's a performance issue, you may want to ask about whether there are any accommodations that can be offered at that point in time. So it would nip in the bud any inquiries about discipline for underperforming employees when there may be a disability at play. Finally, I'm going to talk a little bit about how the code and the AODA work together. As Jessica said, the code has primacy over all other laws in Ontario. It overrides the AODA and other provincial laws when there's a conflict. In fact, the AODA itself states that if there's a conflict between it and any other act or regulations in Ontario, the law offering the highest level of accessibility comes first. The code and the AODA are both provincial laws. Both use the same definition of disability. They don't apply to federal government and federally regulated organizations like banks or airlines or interprovincial transportation companies. These would be covered by either the Canadian Human Rights Act or the Accessible Canada Act. The code and the AODA do work together, but they have some important differences. Under the code, when a person with a disability needs accommodation, as Jessica talked about, there's a duty to accommodate, which means that organizations may need to provide an individualized response to accommodation requests. The code applies to all Ontario organizations, regardless of type and size. The AODA covers employers in different ways depending on the number of employees they've hired. The AODA sets accessibility standards that organizations must meet, and the human rights principles of the code help to inform and guide how AODA standards are to be met. The AOD standards do not limit or replace the requirements of the code or any other lines, and meeting AODA standards doesn't guarantee that an organization has met their code obligations, or that the organization will not receive human rights complaints. On the other hand, if you follow the minimum standards of the AODA, that could lower the risk of complaints. The code is a source of active rights, and those would primarily be rights that an employee might use in making a human rights claim. But as we've talked about, the AODA sets minimum requirements, and they're enforced by the appointment of inspectors who can visit work sites and apply penalties to organizations that don't meet the minimal standards. Jess, I'm going to turn it back to you.
Sure. And I think that's a good time to just pause for the ASL to switch. Something that I apologize, I forgot to do in my first part of my talk.
Actually, you
Diane,
didn't, I did. You remembered, but I didn't. I apologize.
Diane, thanks for taking us through that. Really important how the two pieces of laws, or the two kinds of laws, interact and compare. But that actually brings us to the end of the sort of general overview of the law. And so we've worked in some time for a very quick break. So if people need to get up and, for a moment, we'll allow for that. And then we'll be back here to get started, let's say by, I don't know, in about 4 minutes from now, to get into the sort of practical application of some of these principles and into some of your questions.
Screen transitions to reveal 3 logos: Do the Rights Thing, Arch Disability Law Centre, and Dawn Canada, along with the text, "Discussion not recorded. Thank you for viewing."